The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to answer some frequently asked questions about Illinois divorce. We have longer form answers to these questions at learn-about-law.com. We've got basically an article and video about each of these that goes into a lot more detail. Today we're going to give some brief answers. So first, is there a waiting period to get a divorce in Illinois? The answer is yes and no. There is a 6-month period that the parties have to live separate and apart before they can file for divorce, but this can be waived if mutually agreed by both parties. So if the parties agree to get divorced immediately, they can do so. If they don't agree to do so, then there has to be a 6-month waiting period of living separate and apart before filing. Another question we get is Illinois a 50-50 state for divorce, meaning is all property divided down the middle equally between the parties? And the answer is no. There's two types of states as far as division of assets and liabilities in divorce, and that is some are community property states and others are equitable property division states. Community property states just divide the property in half between the parties. Equitable property division states look at a number of factors in dividing marital assets between the parties to determine how they should be divided, and they try to do it in a fair way as opposed to a blind 50-50 split. Illinois is an equitable property division state, so anything that is a marital asset is divided based on a number of factors that the court determines. This is a pretty long list. I would take a look at our article on asset division to learn more about the different factors that are involved. Do both parties have to agree to get a divorce is another question that we get. The answer to this is no. You can certainly, if both parties are in agreement, a divorce can go a lot smoother. But a divorce can be initiated by either party by filing a divorce petition with the appropriate county clerk, along with a summons, and having the summons and divorce petition personally served upon the other party. That initiates divorce proceedings, and you don't need the signature or consent of the other party to initiate the divorce proceedings. Now, again, certainly if you can collaborate and negotiate and do things as amicably as possible, that can make a divorce a lot quicker and a lot less expensive. A similar question is, can you be denied a divorce? The answer is no. There are a few states where you have to actually prove the grounds of your divorce, like adultery or impotence. Illinois only now has one ground for divorce, and that's irreconcilable differences. And you don't really have to do much to prove irreconcilable differences. So you can't be denied a divorce based on failure to prove the grounds that you're claiming in Illinois. The only way that your divorce can really be denied in Illinois is if you fail to follow the procedural requirements, basically fail to properly file the documents, fail to show up in court, or fail to meet certain prerequisites like the residency requirement that the parties reside in Illinois, or the requirement that they live separate and apart for 6 months. So as long as you check all the boxes for what you're supposed to do to get a divorce, your divorce can't be denied. It can only be denied on basically procedural grounds, not substantive grounds. A question we get a whole lot is, how can I get a quick divorce? Everybody wants to get divorced as quickly and painlessly as possible. So the answer really depends on what causes a divorce to be drawn out and expensive. And that is the parties disagreeing on issues of spousal maintenance, child support, allocation of parental rights and responsibility, asset division, the issues surrounding the divorce. If there's things that the parties can't reach an agreement on, then a divorce will go to trial, and there will be discovery and motion practice. So if the parties can reach an agreement and negotiate to settle as many issues as possible, the more issues that they can agree on, the less duration and expense will be involved in their divorce. So this is when we talk about uncontested divorce. It's basically a divorce in which the parties come to an agreement on everything before filing their case, or most issues. And the parties' attorneys work together to draft up a marital settlement agreement that deals with all the financial issues surrounding their divorce, and a joint parenting agreement that deals with all the parenting issues surrounding their divorce before even filing for divorce. In an uncontested divorce, only one court appearance is required, and it can be resolved within a month, and it's usually much cheaper than a divorce that requires litigation of issues that the parties can't agree on. There's also an expedited divorce process in Illinois called joint simplified divorce. And this is basically an uncontested divorce that also has simpler and fewer forms that have to be prepared and filed, so it's a little bit less expensive than even an uncontested divorce. The problem with joint simplified divorce is that it's hard to qualify for it. There have to be no children involved, and the parties have to be below a certain asset and income threshold. And there's certain other qualifications. So check out our article and video about joint simplified divorce if you want to learn more about whether you might qualify for that. But uncontested divorce is the route that most people go, and that can be pretty as painless as possible in a divorce situation, and as quick as possible, and as inexpensive as possible if the parties can agree on the issues. Another question we get is, can I date during a divorce? You certainly can. Dating will not affect the judge's decision making, so you're not gonna. It's not relevant to the outcome of the divorce itself. The two downsides to dating during a divorce are, one, that it can inflame emotions of the other party and make it hard to negotiate a settlement of certain issues. So if you can collaborate, that's great, and keep things as amicable as possible, that's great, and you can, like we talked about, get a cheaper, quicker divorce the more you agree on things. If one party is dating, that might make it harder to collaborate. More concretely, another issue that sometimes comes into play is that if you date during a divorce, the person you're dating, if there are children involved, may come under scrutiny by the court for the background, because the court will basically look at them when considering the best interests of the child as it relates to allocation of parenting time and responsibility, because they're someone that the child is going to be exposed to. So that's the only way that it can really affect a judge's decision, is when we're talking about children being involved and whether the children should be around the person that you're dating, or how that person affects the children's best interest. Finally, we'll talk about what you can expect from a divorce hearing. A divorce hearing is like any other trial, except there's no jury. The judge decides it. Once you get to the hearing, you've already done discovery work, exchanged written answers to questions from the other side, exchanged documents. Maybe there's been depositions. Maybe there's been some motion practice. But at the trial itself, there will be an opening statement where each party's attorney will basically put forth their argument as to the issues that are in dispute. And remember, there's only going to be a trial based on issues that are in dispute. So if people can agree on everything, there won't even be a divorce hearing. But the divorce hearing is just to determine things that you can't come to an agreement on. So the opening statement lays out each party's position and argument with respect to those issues that the parties can't agree on. Then each side will present evidence, including the testimony of any witnesses involved. Usually that's just the parties themselves, but it can be other people. Any witnesses can be cross-examined by the other side. And finally, there will be a closing statement where each party will sum up the evidence and explain how it supports their argument. After the closing statement has happened, the judge will enter a ruling. Sometimes it's right there and then on the spot, and there will be a final divorce order drawn up on the spot. Oftentimes it will take a week or two to get a final divorce order and the judge's ruling on any contested issues. So those are a lot of our most frequently asked questions about divorce. If you have more questions, we love answering them. Please leave them below the post at learn-about-law.com in our comments section, or in the comments section on our YouTube channel. If you found this helpful, please subscribe to us on YouTube, iTunes, and SoundCloud. And if you'd like a free consultation, please give us a call at 630-324-6666. That's 630-324-6666. We practice a lot of family law, but we offer consultations in almost every area of law, and we have offices all around Chicagoland for your convenience. Thank you so much for listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.